This is Bloomberg Law with June Grasso from Bloomberg Radio.
The Supreme Court is considering a Republican-led effort to erase yet another campaign finance regulation. This time, the federal caps that limit how much political parties can spend in coordination with candidates for Congress. It's the latest in a line of cases where the conservative majority has upended congressionally enacted limits on raising and spending money to influence elections. And 2 hours of oral arguments showed the entrenched divisions between the liberal and conservative justices over campaign finance restrictions. Liberal Justice Sonia Sotomayor said that every time the court interferes, it makes matters worse.
You're telling us that Citizens United and McCutcheon ended up, yes, in amplifying the voice of corporations, but diminishing another voice, that of the party. Now, you want to now tinker some more and try to raise the voice of one party. Our tinkering causes more harm than it does good. Because once we take off this coordinated expenditure limits, then what's left? What's left is nothing. No control whatsoever.
While conservative Justice Brett Kavanaugh said that the spending limits have hurt political parties in an era of unlimited spending by other organizations.
That's the real source of the disadvantage, right? You can give huge money to the outside group, but you can't give huge money to the party, and so the parties are very much weakened compared to the outside groups.
And Chief Justice John Roberts, a potentially pivotal vote, said that he didn't see much distinction between contribution limits, which the court has long upheld, and caps on coordinated expenditures.
It seems to me that that's kind of a fiction, that, they're just coordinating expenditures. They're not making direct contributions. I don't know in substance what the difference is.
Doing away with the caps would overturn a quarter-century-old precedent. In a week when it appears that the court will also be overturning a 90-year-old precedent in a case involving President Trump's ability to fire the heads of independent agencies. Joining me is elections law expert Richard Briffault, a professor at Columbia Law School. Rich, will you start by explaining the federal caps on spending by political parties in coordination with candidates?
So the Federal Election Campaign Act, going back to the 1970s, when it was enacted in the aftermath of Watergate, places limits on donations to candidates. And it also places limits on donations to parties. It does something else. It places limits on how much parties can give to candidates, on the theory that donors, once they max out on how much the donor can give directly to a candidate, would then just give to a party to channel the money to a candidate. So there's a limit on how much the parties can give to their candidates, and that comes up in two ways. One is a literal limit on contributions, actually writing a check. But the parties are also allowed to engage in their own spending in support of candidates. And that's called coordinated expenditures. In other words, the party does the spending, and they don't give the candidate a check, but they do spending to promote the candidate. Parties are allowed to do that, but the law places a limit on how much money they can spend supporting candidates. And again, for the same idea, that if there was no limit on how much they could support candidates through spending, once again, donors who, once they max out on the direct donation to the candidate, would then just give unlimited amounts or very big amounts to the parties. And the parties could then use that money to basically support their candidates. So that's what this limit on coordinated spending does. It's higher than the contribution limit, and it varies from state to state based on the population of the state. But parties are allowed to do this in a way that other organizations are not. PACs are not allowed to coordinate at all with candidates. So parties get this extra permission to support the candidates directly, but with a cap on it. And what's going on in this case is the National Republican Senate Campaign Committee and J.D. Vance, who when this case began was a senator, and a congressman from Ohio, who I think has since retired, have all brought suit challenging this limit on the ability of parties to coordinate their spending with candidates. I should say almost 25 years ago, the Supreme Court upheld this limit in a case called Colorado Republican, decided in 2001. And the court said, yes, because of the danger of conduits, of parties serving as conduits for donor support, these limits make sense and are constitutional. What the Supreme Court is being asked basically now is to overturn that decision.
The liberal justices had concerns, and one that lifting the limits on party spending would lead to quid pro quo bribery, so wealthy donors could bypass the individual contribution limits by donating through parties instead.
I mean, that is the major concern of the liberal justices and of the, I'll call the campaign finance reform community as a whole, is that this will put another hole in the campaign finance laws and make it easier for wealthy donors to channel money to candidates. There's still limits on their ability to give directly, but this would enable them to give through the parties. And so that money would still get to candidates. So yeah, that is the core concern. A second concern is, depending on how the court writes this decision, it could be the green light for further challenges to other aspects of the campaign finance laws, depending on exactly how they write this. So it's both upfront, making it easier to channel money from donors to candidates, and also yet one more case eroding Congress's ability to place limits on campaign money.
What was your take on Justice Sotomayor telling Noel Francisco, the attorney for the Republicans here, that Elon Musk got his position at Doge through a quid pro quo?
More speech is always better than less speech.
You mean to suggest that the fact that one major donor to the current president, the most major donor to the current president, got a very lucrative job immediately upon election from the new administration, does not give the appearance of a quid pro quo?
Your Honor, I'm not 100% sure about the example that you're looking at, but if I am familiar, if I think I know what you're talking about, I have a hard time thinking that his salary that he drew from the federal government was an effective quid pro quo bribery, which may be why nobody has even remotely suggested that.
Maybe not the salary, but certainly the lucrative government contracts might be.
I mean, I think it's fair to say that Elon Musk was, by any stretch, Trump's biggest supporter, unless the biggest financial supporter in the last election, somewhere in the neighborhood of $300 million. And I think that allowed him to ask Trump for special favors, including running Doge, which itself, obviously he didn't get paid for running Doge, but it put him in a position to influence the personnel and the policies of a lot of agencies that have regulatory functions over a lot of his activities, whether it's the SEC or NASA or other organizations that can affect the industries and businesses that he has.
The administration and the Republicans' argument centers on free speech rights, as these campaign finance cases since Citizens United have done. Tell us more about that argument.
The essential argument is that this is a limit on the ability of parties to speak and that you don't need it. That the combination of disclosure laws, anti-bribery laws, and limits on literally earmarking, and that's the term that's used, a donation that a donor gives to a party to be used for a candidate, that's enough. That those three things, banning bribes, requiring disclosure, and saying when a donor gives a party a donation, saying they can't literally say this is going to candidate so-and-so, that's enough. And that to go beyond that is to constrain the ability of parties as free speech actors, as First Amendment actors, to participate in the political process.
What do you think?
So it's hard to say that this is a big constraint. Parties are free to participate in the process. In a fairly controversial decision 30 years ago, the Supreme Court said that parties are capable of engaging in independent spending, that parties can promote their candidates just as long as they don't coordinate with them, just as long as they don't actually sit down with them and say, what do you want us to say? How do you want us to say it? What media do you want to use? So the court, 30 years ago created this vehicle for unlimited party participation in elections. So it's hard to say that this is a big constraint. The defenders of the law argue that in practice, in coordinated spending, the parties actually don't do a lot of literal speechifying. They don't do a lot of actual advertising or promoting. That often what is being used is just to help the candidates pay their bills. So the candidate, basically booked a block of hotels during a campaign swing, or was paying for literature or the candidate's, campaign director makes the commitment, buys the stuff, and then gives the party the bill and says, pay this. That's at least the argument that the defenders of the law were making, that in practice, coordinated expenditures are not parties getting out there and saying this is the party message, but they're de facto contributions to help the candidates defray the bills. That gets constitutional protection. It still enables candidates to campaign, and there's a First Amendment interest, but it's hard to see that this is really squeezing the party's ability to have its own voice.
Justice Brett Kavanaugh said you can give huge money to the outside group, but you can't give huge money to the party. And so the parties are very much weakened compared to the outside group. Is he talking about PACs here, is that?
Yes, he's talking about super PACs. And indeed, that is an argument that many people have raised who don't like this law, including people who might liberals or reformers, who say this law might have made some sense when it was first adopted. But given the proliferation of super PACs and other outside groups, we'd be better off if parties actually had a bigger voice, that parties can play a coordination function, that parties can be a little less extreme than some outside groups, that parties have more of an interest in governance rather than being single issue, and that actually if we could start it all over, now that the outside groups have kind of unlimited voice, that anything that strengthens the parties is actually a good thing. And then you see many people who are not conservatives who are taking that position, who are not First Amendment absolutists, but think that, in fact, the campaign finance system has gotten unbalanced. And it would actually be good to strengthen the role of parties, and this could do that.
Coming up next, I'll continue this conversation with Professor Richard Briffault. So how is the court likely to rule? I'm June Grasso, and you're listening to Bloomberg. The Supreme Court this week weighed Republican calls for a fresh rollback of campaign finance regulations, questioning federal caps that limit spending by political parties in coordination with candidates. I've been talking to Columbia Law School professor Richard Briffault. So, Rich, the Chief Justice suggested that he didn't see much difference between the contribution limits, which the court has long upheld, and the caps on coordinated expenditures. Do you think there's a chance that the chief won't vote with the super conservatives on this to do away with the caps?
Or there's a chance that it goes the other way, and that once they begin to dismantle limits on coordinated expenditures, contribution limits are next. And there was an interesting point where some of the justices asked Mr. Francisco, who is the lawyer for the National Republican Senate Campaign Committee, well, what about that? What about limits on contributions? And he says, I don't want to get into that right now. I kind of want to reserve the right to challenge that down the road. And indeed, some of the liberal justices and the lawyer for people who are defending this law, which I should say is not the government. This is a federal statute, but the Trump administration will not defend it. In fact, they actually joined in the attack on it. So the statute was being defended by two lawyers. One was a lawyer appointed by the court to speak for the statute. In addition, the lawyer for the Democratic Party, for Democratic organizations, also was given permission to argue. And they both argued that basically this is the bait and switch that's been going on in campaign finance law for a long time. Someone says, well, given changes in the law, this particular restriction doesn't make any sense, so you should strike it down. And then they come along and say, well, now that you struck down this one, the next restriction doesn't make any sense either, so strike that down. And there seems to be a kind of a salami tactic aspect to this. A number of the justices are very, very skeptical, more than skeptical, about the constitutionality of the contribution restrictions. They don't have to decide that in this case, but the court has traditionally treated coordinated expenditures as the constitutional equivalent of contributions. If they're going to start protecting coordinated expenditures more, saying that they're more protected from limitation, it's not a big leap to say that that kind of thinking would also apply to the contribution restrictions.
The Republicans are bringing this challenge to do away with the federal caps. So one assumes that they would benefit more than the Democrats, who are fighting to keep the caps. But Justice Amy Coney Barrett asked the attorney for the Democrats which party would ultimately benefit from a ruling. If there isn't an imbalance in who this benefits, why would the DNC be here? And I believe that was the only question she asked.
I think what Barrett was getting at is that the reason you're here, Elias, the Democrats are here, is for pure partisan reasons. That you have less of a merits basis for opposing this and more you're doing it because you think that this will help the Republicans. And if the First Amendment requires it, it doesn't matter who's helped or not. I think there was also some effort to figure out why is it, if this is about a restriction on parties, and in fact, why does one party want to strike it down and one party want to keep it? And does that mean that it operates unevenly across the parties? It's not clear that it does. But if it operates unevenly, it suggests that you're opposing it for partisan reasons rather than on a kind of a merits-based, this is good for democracy.
There was also a standing argument that the attorney appointed to defend the law made. It centered on Vice President J.D. Vance, who was a Senate candidate when he originally brought the case. And the argument is that Vance no longer has a stake in the case and so no standing because he's no longer a candidate. And then there was a lot of discussion about, well, is he going to run for president? I don't think this standing argument is going anywhere, but it's interesting, so tell us about it.
So Ramon Martinez was the man appointed by the court to defend the law when the government declined to do so. And he opened by saying, this case is a big deal. Anytime you're being asked to overturn a precedent that's 25 years old, you should be very hesitant. And you should make sure that this is a case that's jurisdictionally sound. And he basically said it's not, for two reasons. One, so this case was brought by some individuals, J.D. Vance and Congressman Chabot from Ohio, and also by the National Republican Senate Committee. With respect to the two individuals, one of them is actually retired and no longer in politics. So that gets it down to Vance. And Vance has pretty clearly said, I don't know if I'm running. Or more to the point, I don't currently have a plan to run. I mean, apparently he was recently quoted saying, I might run, I might not run. So Mr. Martinez's argument was, well, if that's the case isn't ripe. We don't know if he's running. So there's no candidate here to bring it. And therefore, there's no plaintiff. He's not a good plaintiff because whether he's going to run is speculative. He doesn't clearly have a stake in this case. And then Martinez makes the point that the reason this case goes directly from the district court, this is done by a 3-judge panel. There was an appeal within the Sixth Circuit, but the jurisdictional basis for this going to the Supreme Court is the federal campaign finance law gives sort of a special ability to go directly to the Supreme Court to cases that burden voters, certain other special groups, and the national party committees. And his argument is based on a much older Supreme Court case. The only national committees that get that right are the two top committees, the Republican National Committee and the Democratic National Committee. And he points out there was a decision in the Supreme Court back around 1980 that said that the Democratic Senate Campaign Committee couldn't take advantage of that law. And so his point is the NRSC, the National Republican Senate Campaign Committee, can't do it either. So he's basically making the argument that there's either no standing or a lack of jurisdiction. J.D. Vance could use that, but if he's not a candidate, he can't. So there was some back and forth on that, but it does seem unlikely that, well, you never know with the Supreme Court. But almost all of the oral argument was really focused on the merits of the case.
It doesn't seem as clear as in other cases, but can you tell where the justices are on this? Gorsuch didn't even ask a question.
It's worth pointing out that in every single campaign finance case the court has taken since Chief Justice Roberts became Chief Justice and Justice Alito joined the court, the attack on campaign finance law has won. That's about 8 cases. And turn it around, and there's not been a single case that the Supreme Court has taken since 2005 on campaign finance law where the law was sustained. That's all I think I need to say about that. So the track record, the court hasn't upheld a campaign finance law, federal or state, since around 2003.
Okay, then. So then what would be the effect of getting rid of these federal caps? There are some predictions that it will completely reshape TV advertising for congressional races.
I think that's unlikely. Honestly, I think the system that we have had for the last roughly 15 years, since the emergence of super PACs in a big way around 2010, 2012, I don't know that it's going to change that much. I mean, I think right now, many of these super PACs are candidate-specific super PACs, or they are super PACs that are already run by the parties. Some of the biggest super PACs are the 4 super PACs run by the Republican Senate and House and Democratic Senate and House leadership. If you look at the top 10 super PACs by dollars, certainly the Senate ones are always in the top 10, and I think the House ones often are too. So I don't know that there's going to be a revolution in this. I mean, it's always hard to tell, and it may take a couple of election cycles till we fully see how it works out. But, it's hard to tell. But I doubt there'll be a dramatic change. I think many wealthy individuals just as soon would run their money through PACs that they control, through super PACs. And many candidates, I think, would continue to want to have a super PAC that works just for them. Many of our super PACs now are basically one candidate super PACs. On the other hand, some people do think that maybe it will change the balance and more money will run through the parties. And that could have some benefits in terms of giving the party committees a little more ability to kind of coordinate their candidates, not so much in the election, but in the government that follows. I think that the party committees will have a bit more influence, maybe holding their party delegations in Congress together a bit more. It seems to me lately, given partisan polarization in Congress, they tend to hold together pretty well right now, but it could be that at the margins, parties will be a little bit more unified in Congress.
So if the court upholds the caps, would you be surprised, fall off your chair surprised, or, that's interesting, surprised?
Probably fall off my chair. I mean, when the court upheld this law in 2001, it was a 5-4 vote then. And in terms of just the current majority of the Supreme Court, I guess I'm not sure if Justice Barrett has written on a big campaign finance case, but all the others, the conservatives, have, and they've been rather consistently skeptical of campaign finance. There was a decision in 2021. I think she was already on the court then, though I don't think she wrote on it. She might not have participated given when it was argued, so I'm not 100% sure about her voting pattern. But the other justices have shown themselves to be extremely skeptical of campaign finance regulation.
Well, as you cited the history of the Roberts Court on campaign finance, it does seem like an uphill battle for the Democrats here. Thanks so much, Rich. That's Professor Richard Briffault of Columbia Law School. Coming up next on the Bloomberg Law Show, a golden doodle in a custody battle is the subject of a case that's made its way through 4 of Delaware's courts. I'm June Grasso, and you're listening to Bloomberg.
There's no easy way to say this, Wesley, so I'm just going to come right out with it. Mommy and Daddy are splitting up now.
These laws, Wesley's property?
The outstanding issue is the custody arrangements. I'll assign a veterinary behaviorist.
Wesley's on the verge of psychological disarray.
The movie Who Gets the Dog tells the story of a couple who are divorcing and fight each other in court to get custody of their beloved dog, Wesley. It may seem a little dramatic, but it's not that far from real life. In fact, the custody battle over Wesley mirrors the battle over Tucker, a golden doodle whose owners broke up in 2022 and are still fighting in court over who gets to keep him. Tucker's case has been through every level of state court in Delaware: Justice of the Peace, Court of Common Pleas, Delaware Superior Court, and the Chancery Court, Delaware's elite business court. And now his case is being appealed to the state's highest court, the Delaware Supreme Court. Joining me is Jennifer Kay, Bloomberg Law senior correspondent, who's been following Tucker's saga. So, Jennifer, tell us about the custody battle for Tucker.
So let's just establish, in case anyone hasn't walked around their neighborhood recently, what a golden doodle is. The golden doodle is one of these very trendy doodle breeds. They're very popular. My neighborhood has at least 4 of them. A mix between a golden retriever and a poodle, and the result is a very curly-haired, very energetic and affectionate dog. This one is named Tucker. There is a picture in the court filings. He's a very cute dog. So his owners began dating in 2018, and they moved in together in the following year. And then in 2020, the ex-boyfriend's daughter brought Tucker home as a gift for him. And Tucker was just a member of the family until this couple broke up in May of 2022. They were never married, so that's an important detail here. If they had been married, they would have gone to family court and they would have split all the marital property as normally under Delaware law, and they would have worked out some sort of custody arrangement for Tucker, and we probably would never have heard about him. But that's not what happened because they weren't married. So Delaware law allows family court to take into consideration the best interest of an animal, a companion animal when there's a divorce involved. But since there wasn't a divorce here, this couple first went to a justice of the peace court in 2022 to try to sort out who the dog belonged to. That first court found that the ex-girlfriend was the rightful owner, but two subsequent state courts, the Court of Common Pleas and the Delaware Superior Court, found actually that they shared a joint ownership of the dog, and so that they would have to work out some sort of arrangement. And since they really could not agree, they ended up in Chancery Court about a year ago, a little over a year ago, asking the Chancery Court to figure out what to do. And just again, to remind some of your listeners, Chancery Court is where you go in Delaware when you have a civil case where damages really aren't the answer. You're looking for a judge to figure out what's equitable, like what's happened, was what happened fair, and how to fix it if it wasn't fair. So that's kind of where we are now with this case.
And there was a hearing where a veterinary behaviorist testified?
In the spring, the Chancery Court said, look, you guys really can't agree. Fine. We will follow the procedures under Delaware property law because Delaware law looks at dogs as property. I don't want any of your listeners to come at me. That is not my personal opinion. I know people have very strong feelings about their fur children, but they're property. And under Delaware law, if there's property and you really can't agree about who gets what, the rule is to partition it. Sometimes that means actually splitting something in half. No one is suggesting that Tucker should be split in half here. So the court left it up to this estranged couple to figure out, how are you going to split Tucker? Like, this is what the law says. We need to partition this property. You need to figure out what that means. They could not figure out what it meant. This couple just could not figure it out. So they came back to court, and a part of that was an evidentiary hearing about who's actually taking care of Tucker, who did what when this couple was actually living together. That was 3 years ago now. What is Tucker's health and well-being at this point? And that's where the veterinary behaviorist came in and said, well, you know, Tucker, I think like a lot of doodles, has a few issues. He's got some anxiety. He doesn't really deal with changes to his routine all that well. So that's where the evaluation of Tucker came in. But the court ultimately decided, in this case, if you really can't agree, what partition is going to mean is a private auction. It's just going to be this estranged couple, just the two of them. Whoever is the highest bidder will go home with Tucker, and the other person will get compensation.
So the judge then decided not to base it on Tucker's best interests?
That's right. And that's a really interesting point, because that is kind of different from the trend in a lot of these cases. And there are more and more of them all the time, even in situations where people aren't romantically involved. There was a trial in Philadelphia recently over a cat named Gary. Two ex-roommates, each of them wanted Gary. What some courts are looking at is what's in the best interest of the animal. They're looking at them as a little bit more than property, and they're kind of borrowing from these state laws in Delaware, in California, in New York, and other places where if there's a divorce, the companion animal, the pet, will be evaluated under the question of what's in the best interest of the animal before deciding who is going to take it. So some courts have applied that standard in these other cases where you have a couple that weren't married, or, you know, it's roommates, there's no romantic relationship. But here, the Chancery Court judge says, you know, I see what other courts are doing, but I'm not convinced that the best interest standard is the way to go here. What Delaware law calls for is a partition, which is an auction that will maximize the value of the property, and there's no reason to move away from that default.
I mean, just how does the auction work? Is the bidding open and it keeps going up and up, or is it sealed bids?
So again, unfortunately, the court is kind of stuck with putting it to a couple that really are not getting along to figure out what to do. A partition trustee has been appointed by the court, a third-party attorney, if you will, but they haven't gotten to that point yet because the ex-boyfriend has sought to appeal this ruling to the Delaware Supreme Court in a mid-case appeal, basically an interlocutory review. He wants to stop the auction and have the high court consider the case before he potentially loses Tucker. This couple, I think the legal term here really is this is a very bad breakup. They've also been fighting over other property, according to the court documents. They've actually been fighting over actual literal property and threatened litigation over something that they also had bought while they were together. So it's not just Tucker that they're fighting over.
As I understand it, the woman hasn't seen Tucker since the breakup. So best interest, I guess, if Tucker has separation anxiety and distress, would put him with the man.
It's a very much a he said, she said kind of situation. If you go into the briefs, the ex-girlfriend said Tucker was her companion animal, her support animal during cancer treatments while she was still in the relationship. But then the ex-boyfriend, after the breakup, that he took Tucker out of state and prevented her from seeing him all this time. The ex-boyfriend says, no, this dog was, again, a gift originally from my daughter. He was abandoned by the ex-girlfriend when we broke up. He's been my best buddy this whole time. I care for him all the time. And it's really the ex-boyfriend saying, you really need to look at the best interests of Tucker here, whereas the ex-girlfriend is saying, this was property we both shared, and we need to come to a resolution.
So what's the next step? The ex-boyfriend is appealing?
So the ex-boyfriend filed a motion for an interlocutory appeal. It's kind of asking the Chancery Court, can we have the Delaware Supreme Court step in here, even though we haven't gone through a final order? And the Chancery Court denied that. So where he's left now is he could go to the Delaware Supreme Court on his own and ask the justices to take his case, kind of mid-case, to review it. The justices could decide to do that. They could deny him and tell him that he has to wait until the auction happens, which is where the Chancery Court said the case should go. The Chancery Court has said, look, you've had the dog all this time, so you won't be harmed by putting a hold on the auction. But the ex-girlfriend will be harmed because she hasn't seen the dog in 3 years, and a dog only lives so long. This dog was a puppy in 2020 when it was first acquired, then it's already 5-6 years old.
The costs involved, they've been through every level of Delaware court and now possibly the Delaware Supreme Court. I mean, what are the costs involved here for attorney's fees and expert witnesses?
I don't know a dollar figure for what these people are spending individually, but what the ex-boyfriend has said in his briefs is that, he's already had to pay $35,000 to this ex-girlfriend over the other property that they've been fighting over, that they reached a kind of settlement over that. And he says, look, she wants an auction because she knows that she has the superior finances compared to me, so that's not fair. We aren't on equal footing here. Again, I can't speak to what exactly each of these parties is spending, but it has to be a lot if you've gone through basically every level of Delaware state court except family court. And the only reason you haven't gone to family court is because you weren't married in the first place.
So is it unusual for the Chancery Court to be sorting out disputes over animals?
Most people probably, if they know Delaware Chancery Court, they know it probably because of Elon Musk over the last couple of years. This is the court that told him, no, you can't have $56 billion as your pay package as being the Tesla CEO. That's a case that is before the Delaware Supreme Court right now. It's also become very unpopular in certain corporate circles over some other court rulings. That's largely stemming from its role as a court of equity. Again, you go here when damages aren't necessarily going to fix the problem. You need to figure out, was a transaction fair? And if it wasn't, how to fix it. But because it's a court of equity, it also has this other role where it has to decide local property cases. And that's where you end up with cases like Tucker. You and I spoke earlier this year about another case where Elon Musk's judge, the one that he probably hates most in the country, had to decide what to do with a man who said, my Clydesdale, my horse, and I were in a car accident. The horse was euthanized and taken to a landfill without my consent, and now I want the horse back because I don't want to bury it in a landfill. And so she had to decide that while also deciding matters pertaining to Elon Musk. So it can be this really interesting court where you have very, very important corporate questions, but also very, very important questions to the local litigants that just want to do what's best for their pet. And, it's interesting that the judge in this case, Vice Chancellor Bonnie David, One of the other big corporate cases that's on her docket involves Fox News and the big settlement, the $800 million settlement that it had to reach over defamation claims stemming from the 2020 election broadcast that it made. So she also has quite a bit on her docket, but she, in her opinions, has cited a number of cases from other state courts. And a lot of them involve pets that were acquired by a couple who didn't get married, so they couldn't go through family court. And it's interesting that a lot of them kind of follow a similar path, that they take years to figure out. And you really have to think about it in terms of, like, how many dog years is this case going to take? Because if it can take like 4 or 5 human years, that's a long time for a dog. If this auction moves forward, it's unclear still, like, one, exactly how that would look. 2 is how much it would cost. And then 3, how are you going to enforce it? Like, is a deputy going to show up at someone's house for the dog? And then if you appeal it, what happens to the dog in the meantime? There's a lot of unanswered questions here. And we're talking about it because this is a case that is setting all kinds of precedent for the Chancery Court in these property disputes. This is really the first time it's had to deal with a partition case involving a living, breathing being.
So now prenups have to include, if we have a pet, what happened to the pet?
You're joking, but that is actually what an animal law expert, an attorney practicing in the animal law sphere, told me. She said, yeah, you have to really think about these things much like a prenup. Even if you are just roommates, there's no romantic relationship. If you get a pet with someone, you need to make a contract so that you can plan for what happens when you're no longer living together, which I think absolutely no one thinks about when they're looking at a kitten or a puppy.
Well, you'll have to let us know what happens to Tucker. Thanks so much, Jennifer. That's Bloomberg Law senior correspondent Jennifer Kay. And that's it for this edition of the Bloomberg Law Show. Remember, you can always get the latest legal news on our Bloomberg Law podcast. You can find them on Apple Podcasts, Spotify, and at www.bloomberg.com/podcast/law. And remember to tune into the Bloomberg Law Show every weeknight at 10 p.m. Wall Street time. I'm June Grasso, and you're listening to Bloomberg.